You were certain that her affair would tip the scales in your favor. After all, cheating feels like the ultimate betrayal. You expect the court to stand up, shake its fist at infidelity, and reward your loyalty with a cleaner split, heftier alimony, or full custody of the kids. But what actually happens is the opposite. Courts shrug, treat adultery as a personal matter, and get back to business as usual. Meanwhile, you're left writing checks, sharing assets, and wondering why you're the one paying for her mistakes. The truth lies in the rise of no-fault divorce laws. Once you file under irreconcilable differences, the judge isn't evaluating who broke the vows, only how to divide joint property fairly. And fairly usually means splitting marital assets and debts based on contributions, needs, and the length of the marriage, never on moral high ground. If you want to use her affair as leverage, you must prove that she squandered marital funds on romantic getaways or lavish gifts. And that battle costs more than it's worth, dragging you into an expensive, invasive hunt for bank statements and hotel receipts. Even evidence gathering is a minefield. Hidden camera footage, surreptitious recordings, GPS logs. Many of these tactics face legal challenges or privacy objections that render your proof unusable. Judges don't want to sanction espionage in the name of fidelity. They want custody plans, support figures, and property distributions, not a play-by-play of who was where with whom. And when it comes to alimony and child custody, fault rarely matters. Support depends on income, standard of living, and financial need, while custody revolves around stability, bonding, and the child's welfare. An unfaithful spouse can still be deemed the better primary caregiver if they provide consistency and security. If you're expecting infidelity to pay dividends in divorce court, you're in for a shock. In the next few minutes, we'll expose 7 reasons courts won't punish her cheating, but will still make you pick up the tab, so you can stop chasing moral justice and start protecting your financial future. No-fault divorce changed everything. Decades ago, you might have stood in court arguing about betrayals, and a judge could weigh adultery when dividing assets or awarding custody. Now, in most states, you file under irreconcilable differences or irretrievable breakdown, and that's it. No moral ledger, no blame. Once judge stamps the no-fault petition, your ex's affair is officially out of bounds. The court's job is to untangle your finances and parental responsibilities, not to adjudicate character. That means the moment you choose no fault, and 99% of couples do, you waive any expectation that cheating shifts the scales. Your only path to leverage infidelity is proving marital waste, which requires showing she spent marital funds on the affair itself. You need bank statements with suspicious charges, travel receipts for exotic getaways, maybe even account expert testimony on gift expenses. All that evidence gathering racks up legal fees faster than a trial over a Ferrari. Judges rarely award more than they can tie directly to wasted dollars. So even a clear case of lavish spending usually translates into modest reimbursements, not a windfall. In practice, pursuing fault turns you from a wrong spouse into an investigator. Hiring forensic accountants, subpoenaing credit records, paying for private investigators. For each suspicious hotel stay, you'll need proof her spending above normal living costs funded the affair. Even if you succeed, the court subtracts only the documented excess from a marital estate. Everything else, your pain, your loss of trust, is dismissed as collateral damage, not a factor in property division. So while infidelity feels like a legal trump card, no-fault divorce turns it into a wild goose chase. If you want tribunals to punish her betrayal, you're fighting the system itself, one designed to move past gossip and focus on equitable outcomes. And that brings us to the next reason your moral victory won't pay your bills. Courts don't slice up the marital pie based on who is more virtuous. They carve it with equitable division, not equal blame. In a no-fault regime, your ex's infidelity doesn't automatically tip the balance toward you. Instead, judges examine factors like each spouse's financial contributions, the duration of the marriage, and the party's future needs. If she was the higher earner or you took time off for childcare, that matters far more than her personal conduct. Imagine a marriage where she earned 70% of the household income while you manage the home and kids. Even if she cheated, her financial stake remains dominant. The court will consider your unpaid labor, home maintenance, emotional support, parenting, but it won't penalize her for betrayal. Your contribution gets a sympathetic mention, yet the property division still follows the scale of economic participation and need. Some states allow consideration of marital fault, but infidelity only counts if it directly impacted the marital estate through wasteful spending or other financial loss. Otherwise, it's treated like background noise. Judges focus on splitting the mortgage, retirement accounts, investments, and personal property so that neither party is left destitute, not on whether one spouse deserves punishment for personal failings. Even in jurisdictions that permit fault considerations, adultery rarely outweighs other factors. A spouse who gambled away joint savings or embezzled funds from family business might face a financial penalty, but mere emotional betrayal, no matter how painful, almost never triggers an additional award. You can present the affair as context, but the final decree uses charts, valuations, and statutory checklists, not moral judgments. That's why chasing infidelity in property division feels like searching for a lever that doesn't exist. Instead of bleeding the marital estate further, trying to prove fault, you're better off focusing on the true drivers of division: retirement balances, real estate equity, debt allocation, and earning capacities. Those are the levers courts actually pull. Fault is just hot air unless it burned a tangible hole in the joint wallet. Proving marital waste, that is, showing she literally spent your joint money on trysts rather than household needs, sounds like the perfect revenge. But in reality, it's a costly uphill battle with minimal payoff. To bring a waste claim, you have to tie each dollar spent to the affair itself. That means combing through years of bank statements, credit card bills, and travel receipts to spot odd hotel charges, unexplained gift purchases, or flight bookings. You'll need a forensic accountant to trace funds, an investigator to validate dates and locations, and likely a financial expert to testify in court. Every expert comes with fees that run into 5 or even 6 figures, and those expenses often dwarf any extra amount you hope to recover. Even if you manage to prove that she spent $20,000 on romantic getaways, the court's typical response is to deduct that sum from the marital estate. Nothing more. You won't see punitive damages or an increased property award beyond those documented losses. Meanwhile, you've spent tens of thousands on legal and accounting fees, so your net gain could easily be negative. That modest reimbursement rarely justifies the emotional and financial investment required to pursue it. The court also scrutinizes timing. If she transferred funds months after the affair, or used joint credit lines rather than her personal account, you have to connect the dots precisely. Judges aren't sympathetic to broad accusations of waste. They want a dollar-for-dollar accounting. Vague allegations won't cut it. And if your claim drags out settlement negotiations, you'll erode any goodwill that might have led to a cleaner, cheaper split. Mediators see waste claims as aggressive and time-wasting, which can sour negotiations and actually increase your overall legal costs. In addition, by the time your forensic report and subpoenaed records land on the judge's desk, the court is already primed to finalize asset division based on equitable benchmarks. Judges tend to wrap up cases rather than prolong them with side disputes about whose romance cost more. That means your window to introduce a waste claim and win slams shut quickly. Bottom line, marital waste sounds tempting in theory, but in practice it's a boomerang that hits your bank account triple. You spend big to prove a relatively small sum, and the court caps you at that sum. No more. If you want real leverage, focus on negotiating fair splits of retirement, real estate, and support instead of chasing the phantom of moral victory through waste claims. Courts aren't eager to wade through salacious details of secret rendezvous, and digging for dirt can actually backfire on you. If you're tempted to install hidden cameras, hire private eyes, or subpoena her phone records for every flirtatious text, think again. Judges view those tactics as invasive, often deeming the evidence inadmissible or even sanctioning you for violating privacy. Imagine presenting grainy footage from a nanny cam tucked behind a potted plant, hoping it proves her affair. The judge could throw it out because it wasn't legally obtained and scold you for harassing your ex. Or you might serve overly broad subpoenas for all her digital communications, only to watch the court quash them as fishing expeditions, ordering you to pay her attorney's fees. Rather than exposing guilt, you'll brand yourself as litigiously hostile and lose credibility. Even text message chains, though tempting, come with their own pitfalls. Screenshots can be easily manipulated. Metadata, timestamps, and sender IDs often get stripped when copied, making them unreliable. If you can't authenticate a message's origin or prove it was sent when claimed, the court may exclude it. And in many jurisdictions, recording someone's phone call without consent is illegal, risking criminal charges that derail your case entirely. Worst of all, the more you focus on infidelity evidence, the more you distract from the real issues: asset division, support, custody. Mediators and judges want to resolve financial and parenting matters, not adjudicate a morality play. By turning the proceedings into a quest for proof of cheating, you risk dragging out negotiations, inflating legal bills, and alienating the very decision-makers you need to persuade. If you suspect your ex of betrayal, channel that energy into strategic documentation, bank statements showing unexplained expenses, credit card record for travel costs, but avoid invasive tactics. Focus on the financial trail, not the bedroom drama. Courts respect clear, legally obtained evidence tied directly to your claims, not the lurid details of personal misconduct. Mediation is designed to end disputes quickly, not to mete out moral justice. And the minute you turn your settlement talks into a crusade against infidelity, you lose the very leverage you need. Skilled mediators guide both parties toward compromise, steering conversations away from blame and toward asset division, support formulas, and parenting plans. If you insist on pausing every negotiation to litigate her affair, arguing over hotel receipts, or demanding extra concessions as punishment, you'll anger the mediator and your ex's lawyer, sharply driving up costs and dragging out the process. Mediation sessions run on tight schedules and fixed fees. Every hour you spend rehashing the affair eats into that time, forcing you to pay for extra meetings or risk leaving critical financial details unaddressed. Instead of focusing on your retirement split or debt allocation, you find yourself revisiting emotional betrayals that carry no weight in the final agreement. Mediators aren't there to resolve emotional wounds. They're there to draft enforceable settlements, and they won't tolerate endless detours down memory lane. Worse, when you silence the practical issues in favor of moral lectures, you alienate your ex and polarize the room. A resentful opponent digs in, refusing reasonable offers and prolonging each counterproposal. What could have been a 1 or 2 day mediation stretches into multiple weeks, each session billed at hundreds of dollars per hour. By the time you finally sign, the penalty for her cheating has cost you more in mediator fees, attorney hours, and emotional energy than any financial gain you might have argued for. Even if you reach a mediated agreement that factors in fault, perhaps a small waste reimbursement, the court will treat it as a contract between two parties, not a vindication of your morals. And if that agreement is flawed or unfair, it's binding. Judges rarely unravel mediated settlements, except in cases of fraud or incapacity. So if you let infidelity derail your focus, you risk locking in poor financial terms that you can't revisit later. The smarter approach is to keep mediation centered on the issues that matter in court: asset values, support numbers, custody schedules. If you have credible evidence of waste, introduce it succinctly, then shift back to pragmatic negotiation. Let the mediator know you're serious about a fair deal, not a moral reprisal. That way, you harness mediation's strength, speed, lower cost, confidentiality, while avoiding the traps that turn a productive session into a punitive back and forth. Because in divorce, the path to financial stability isn't paved with moral victories. It's paved with clear, strategic agreements that stand up in court. When it comes to custody, the court's mantra is best interests of the child, not punish the unfaithful parent. Even if her affair disrupted family life, what matters are stability, bonding, and parenting ability. Judges look at who provides routine care, emotional support, educational involvement, and a safe environment, not who kept late-night company with someone else. You could present proof of infidelity, but unless it directly endangered the children, exposing them to inappropriate situations or neglect, it holds little sway. A spouse who cheats but maintains a consistent bedtime routine, attends school events, and ensures financial security can still win primary or joint custody. Conversely, a faithful parent with a chaotic schedule, frequent job changes, or instability may lose out, regardless of marital fidelity. Pursuing custody adjustments on the grounds of infidelity can also backfire. If the judge sees it as a tactic to tarnish the other parent's character, they may question your motives and view you as confrontational. That perception alone can undermine your case, making you seem more interested in retribution than co-parenting. Instead, gather evidence that speaks directly to the children's welfare: school records, pediatrician notes, and testimony from teachers or counselors. Demonstrate your own caregiving, logs of pickups, doctor visits, extracurricular involvement. Let the court see that your primary concern is the kids, not your spouse's romantic missteps. Remember, courts want to avoid parental warfare. They encourage shared parenting plans and stability. By focusing on a child's needs rather than on moral judgments, you position yourself as the reasonable, child-centered parent, and that approach is far more likely to shape custody arrangements in your favor. Spousal support isn't about punishing the cheater. It's about balancing financial need against the payer's ability, and fault rarely factors in. You might assume that because she betrayed your trust, the court will reduce or eliminate your obligation to pay alimony. In truth, judges calculate support based on income disparity, standard of living during the marriage, and the duration of financial interdependence, not on who stepped out of bounds. If you are the primary earner and your ex sacrificed career opportunities to manage the household or raise children, you'll likely owe support for a period that reflects that dynamic, regardless of her personal conduct. Some states allow fault to modify alimony, but even then adultery must be shown to have directly harmed the marital estate through wasted funds or career impacts to shift the numbers. Simply proving emotional harm won't move the needle. Furthermore, if you insist on dragging her affair into spousal support hearings, you risk antagonizing the judge. Courts view alimony as a tool to prevent unfair economic hardship, not a moral rebuke. Judges want clear financial data: pay stubs, tax returns, expense reports. They want evidence of earning capacity, employability, and potential for rehabilitation. Everything except a play-by-play of your ex's personal life. The moment you turn support discussions into a morality trial, you undermine your own position as a rational, future-focused partner. A smarter tactic is to craft support arguments around quantifiable factors. Propose a term that aligns with your ex's projected time to achieve self-sufficiency. Suggest a formula tied to cost of living or completion of education, or negotiate a lump sum buyout if you have access to non-retirement assets. By steering the conversation back to data and practical solutions, you demonstrate the sort of stability and problem-solving approach that courts reward, while keeping your payments as controlled and predictable as possible. At the end of the day, chasing fault in alimony is like trying to use a broken compass. It leads you nowhere. Focus instead on your true leverage, your documented income, your living expenses, and the realistic timeline for support. That's how you minimize your long-term financial obligations, not by hoping the court will penalize her indiscretions. Divorce courts have moved well beyond moral judgments. Infidelity simply doesn't pay in family law. No-fault filings, equitable property division, narrow waist remedies, invasive evidence limits, mediation focus, child-centered custody rules, and need-based alimony calculations all combine to shield the system from personal vendettas. If you spend your energy chasing her affair, you'll only rack up bills and miss the real levers you can control: asset protection, clear evidence, strategic negotiation, and data-driven support planning. Redirect your fight from who is unfaithful to what truly matters, your financial future. Take charge of the facts, not the betrayals, and you'll come out stronger on the other side. Courts are built to untangle finances and protect children, not to mete out moral judgments. You may feel that her betrayal deserves punishment, but the legal system sees adultery as a personal wrong, one that rarely moves the needle on property division, support, or custody. No-fault divorce laws remove the blame game. Equitable division focuses on contributions and future needs, and waste claims only cover documented losses, not emotional damage. Pursuing salacious evidence can backfire, stalling mediation and inflating legal bills. Custody hinges on stability and caregiving, not bedroom drama. Alimony formulas ignore who cheated and zero in on income gaps, duration of the marriage, and standard of living. The real leverage comes from clear documentation, strategic negotiation, and protecting your assets, retirement accounts, property interests, and support terms, rather than chasing moral vindication. If you tie up the process in fault-based battles, you hand the advantage to the system. Fast-moving judges eager to close files, mediators focused on compromise, and statutes that prize predictability over punishment. Instead of expecting a court to penalize infidelity, channel your energy into what courts actually care about: accurate financial disclosures, evidence of contributions, practical parenting plans, and realistic support proposals. Lock down your nest egg with QDROs, safeguard custody with child-centered documentation, and negotiate support terms that reflect your earning capacity and cost of living realities. That's how you protect your future, minimize your bills, and emerge from divorce with the peace of mind you really deserve, without getting lost in a moral maze the courts won't enter.